That might.
Okay. Happy New Year, everyone. I'd like to convene the January 2nd, 2024 meeting of the Injured Employee Partial Permanent Disability Payment Working Group. Representative Conley, do you have any remarks?
Good morning and happy new year. I know that we might be a little short of or have limited people on today. We had some folks with illness, some folks were on multiple meetings. It seems to be that 2024 is a busy day, the first work day back. So while folks watching may only see a few faces, many others are listening and we appreciate your input. If you're not able to join, please email your thoughts or comments that you wanted to say if you're on the working group.
Right. Thank you. Then we'll start off with a motion to approve the minutes from the December 12th meeting.
So moved.
Second?
Second.
Thank you. Any discussion, comments, questions, corrections, changes? Seeing none, we'll proceed to vote. All in favor, say aye.
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 Opposed?
Aye.
Opposed? Motion carries. All right, we'll pick up then where we left off last time. Last time we were discussing changes that had been presented by Nate Schaffner and Bud Drapo, namely changing the cervical spine from 117 weeks to 374 weeks, creating a disability rating for the skin of 208 weeks, less any scar or disfigurement paid, changing the hands from 164 for the master hand, 155 for the minor hand, to 208 for the master and 194 for the minor, which are what currently are the disability ratings given for the elbow up. And then also creating a catch-all that would allow for a workers' compensation judge to award permanency benefits of up to 520 weeks for any unlisted body parts. I don't think that would come into play very often, but there are limited scenarios where that might be an issue, and certainly the claimant shouldn't be denied a benefit because the body part hasn't been listed. Also, there were proposals to amend the 31308A statute to allow claimants to continue to collect those benefits if they're taking advantage of vocational rehabilitation services. If they're doing job searches, they would be paid at their base rate, and it would not limit job searching to those residing out of state, and it would cap the 308A benefits at 208 weeks or whatever the number of weeks of compensation the person received, whichever was the greater number. So 208 weeks would be 4 years of potentially 4 years of benefits if you met those other criteria. And I know that we had a good discussion back and forth on different proposals related to that. And I wanted to pick up the discussion from that point going forward. And, I'll start it out. If anybody has any additional comments or wants to add anything further to what was discussed at the last meeting. Anyone, one way or the other?
Oh,
Go ahead, Rep. Conley.
I'm just going to speak about a housekeeping matter. It's come to our attention that the agenda shows up on CGA Lights, which is available for representatives and staff to see, but isn't on the public website. So I understand our staff's going to fix that problem.
Okay, thank you. Yeah, I mean, fortunately, it wasn't a meaty agenda, so I don't think we'll have any issues with that. But again, any further discussion on what was put forth at the last meeting? Are there any areas that any of you feel that we haven't thoroughly addressed that we should be more thoroughly addressing? Okay.
Yeah, hi. I'm sorry, I just couldn't get off of mute. This is Colette Griffin. So a couple of things I think just to mention, I think we discussed those topics. I don't think there obviously was an agreement as to how to address them. So I just wanted to make sure that was clear. I think what you recited was the proposal that Nate and Bud had prepared. But we did have back and forth regarding some of the issues that we had with regard to both the increased permanent impairment ratings, including not having any concrete information or evidence regarding the inadequacy. And then there were concerns about the going back to what was taken out of the statute regarding the unscheduled body parts. It had been my understanding that that was taken out because they addressed the body parts that the legislature felt were the body parts that should have a permanent impairment rating. So those were just some of the concerns. I just wanted to be clear that there were issues with those things.
Colette, you having practiced in this area for a long time, as many of the rest of us have, do you have any, I mean, do you think that the status quo is correct, or that some changes should be made? Not necessarily agreeing to the changes that were proposed, but any thoughts that you have on where you've seen circumstances where a differentiation in the rating numbers might be a benefit?
I have been practicing for a long time, both before the 93 changes and after. And, you know, I'm very aware of in 93 why many of those changes were made. So, you know, there's always a situation that one can say, is this adequate? But I think we have to look more uniformly across the board. And it seems to me that the Connecticut workers' comp system, you know, does tend to address the issues quite well, at least from my perspective. You know, and I don't know that the question is whether there are things that should be changed. I mean, we're all part of this working group to try to come up with, you know, if there are changes, what would be appropriate. And certainly I'm happy to discuss that. But I think as it stands, the proposal that was made to me goes far outside of what I think would be sustainable and is, so I guess that hopefully that answers your question, right?
Yeah, it does. You know, are there any changes that you think should be made. And again, I'm not marrying you to the proposal. And if your answer is that things are sufficient the way that they are, I mean, that's fine as well. I'm just curious from a respondent's attorney perspective, what your thoughts are.
Yeah, I think, in my view, we need to look at what our goals are, what the goal of the Workers' Compensation Act is, and deal with to whether the Workers' Comp Act accomplishes those goals. And I have to say that in large measure, I feel like those issues are addressed either by the legislation or by legal opinions. A good example would be the rating for the skin. I do think that we have ways to address those injuries that can be severe, the burn injuries, but I think in the cases I've handled, I have seen lawyers address that in very meaningful ways, aside from providing a rating to the skin, which is so broad. And so I think in many ways we can deal with those issues with the existing legislation that we have.
Okay. All right. Thank you. Not trying to put you on the spot, especially driving, but
Yeah.
just figured I would.
Yeah. Thank you for that. Yeah.
You're welcome. You're welcome. Anyone else have any comments? One way or the other, quite frankly. You're turning this into a quick meeting. Yeah, go ahead, Brooke.
Hi, good morning and happy new year, or good afternoon, I should say. I just wanted to reiterate again that our position is still the same, that we still feel that the benefits are adequate, especially given the numbers that I sent on our last meeting. And we still feel like things can be handled in the appropriate manner with the current setup that we have in the statute and with the legal opinion, current legal opinions, as Colette just stated. And so, our opinion hasn't changed in that manner. I just wanted to let you know that.
Okay. No, thank you.
Representative Quinn, I just have I'm still learning this, and I'm not nearly as skilled as I came into the bar in 1993, so I'm not familiar with the way things were beforehand. I just have a question, really, and I don't know if this is helpful or not, or relevant even. This is the thing I keep thinking about when we're having this conversation. It's like, when we think of 117 weeks, in terms of whether that's adequate compensation for the NAC. And I know there was some data discussed last week about how at the last meeting about comp rate and all that stuff, but has there been an analysis made with respect to, the fact that comp in the 80s and 90s, these people were mostly manufacturing people. The average weekly wages, I would imagine, would be, comparably higher to what we're seeing on, allowing for inflation and changing the economy and things like that. But, when I see people coming in with serious neck injuries and minimum comp rates, people that are working, 2 jobs, right? So you've got the whole concurrent employment issue and the second injury fund challenges with that, or someone that's working, 28, 30 hours a week at minimum wage plus, as a picker at Amazon, and they've got a serious neck injury. I don't know how 117 weeks at that comp rate is accomplishing anything. That person's going to be living in their car at some point. And I'm sure Nate and Bud can talk about from the claimant's point of view of having people that have contacted us in those circumstances. So when we talk about whether or not the current situation is adequate or responsive, I just want to know, has there an allowance been made or an analysis been made with respect to, the type of the average, the jobs that exist in the current economy versus what existed 30 years ago in the Connecticut economy. And so that's where I come from. My perspective is that's why I think 117 weeks on the neck is inadequate. It's because I don't think it's inaccurate. I mean, it doesn't make the worker whole, or to get to the place where that person can get to a safe, a lifestyle where they can get back to go back to work. They're always going to be behind at that point. And then the challenges mount on top of one on top of the other. I think you understand what I'm trying to say. So that's what my question, or I don't know if anybody, Nate or Colette, who've been around that long. They don't look that old, certainly. I can say that. They both don't look that old. But, I'm curious what their thoughts are on that.
I have some thoughts on that.
Yeah, go ahead, Nate.
Prior to the amendments in 93, there were more safety nets in the workers' compensation system, albeit the comp rates were lower, but there were more safety nets. First of all, these impairment ratings were higher. Second of all, when you're on total disability, you got cost of living adjustments every year. We no longer have that. You only get that starting after 260 weeks. Third of all, there was also in terms of vocational rehabilitation, which was, I think, used more some time ago. There was a stipend that was paid to the injured worker if they were involved in the program. The other thing that existed is that in those unforeseen cases where the injured worker couldn't get back to work, the judge or the commissioners back then had the ability under 308A with this unlimited discretion to fashion a remedy that would award the person benefits, whether they were in retraining or they did find a job that was light duty, that would sort of bridge the gap more. All those safety nets, which I just enunciated, are gone. In addition to that, while the comp rates have gone up, and we know that, and we keep looking at the max rate, and you say, well, Connecticut's got a $1,500 a week total disability max rate. The average client that comes into my office isn't getting that max rate. And, someone who's earning $60,000 a year, which is approximately, $1,200, which is about $1,200 a week, their comp rate's going to be between $500 or $600. You take a rating to the neck where they've had a cervical fusion, and if you're lucky, you got a 20% on that. They're looking at 22 weeks, 23.4 weeks of benefits. It's about $12,000. You add in the 308A for another 22.3 weeks, which is not going to be at the $600 a week rate. It's going to be less than that. Let's assume it's, if they're lucky, they'd get $400 a week. That's another $8,000. So then you're essentially saying you got your 308A and your permanency for that 20% to the neck. And, here's, over a period of 45 weeks, here's $18,000. And that's it. So without those safety nets, and then when you couple the fact that these ratings have been reduced, you do end up with these, a lot of cases are unprovided for in terms of there's just no longer these safety nets, which is why I think a lot of people, you see a bigger influx into people trying to get Social Security disability, because that does create a safety net. So either you increase the benefits or you increase the safety nets within the system. And the best way to increase the safety nets within the system is to allow judges to make these discretionary awards in those cases where they feel it's appropriate. And what Bud and I have crafted is really a framework within it. It's either increasing these benefits or increasing some sort of additional discretion, which these judges are, recommended by the governor and approved by the legislature to fashion these remedies. And these are broad strokes, as Colette and Brooke have alluded to, but that doesn't mean that we can't find some middle ground to find a balance in there. So to say they're adequate, well, yeah, they're adequate. But is adequate what we want? Is really, when you take away someone's livelihood, is that what we're looking for, is adequacy? I think we can do a little better. It's just my thoughts.
Thanks, Nate. Nate, how was the stipend calculated and paid?
That I don't know. I just remember I think it was calculated by the chairman or the commission. And back then, I think the director of Division of Workers Rehab was a man named Tony Skiff. And I'm not exactly certain how those are calculated. There are some older commissioners I could ask about that, but I think Commissioner Waller's still around. I could ask him how that was. I just remember that they would get it was close to their comp rate, but it wasn't exactly their comp rate. So,
okay.
But I can dig that information up. That won't be too hard to find.
All right, thank you.
My recollection of Nate, it came from the Department of Rehab, not from the workers' comp side of it.
That's probably right. You're probably right.
Okay.
Yeah, I would like to just point out, Nate's discussion. Thank you, Nate, for your discussion. Really focuses on the cervical spine. If we were to limit it to the cervical spine, that would be one thing. But what has been laid out is obviously far exceeds the cervical spine.
You mean bringing up the skin and the hands and things like that? Is that what you mean, Colette?
Yes.
Well, those were brought up, and I agree with you, Colette. There was a big laundry list, but not a big laundry list, but it was a number of items. But as I stated in the opening remarks when this committee began, these were the areas that of which people have expressed to myself or in general that felt, and even judges have expressed that, whether they're referring to one case scenario, such as you might find a skin where you can't get an appropriate rating on a different body part, or you think that the hands were inadequate and that they should be a number of weeks higher. So I figured, okay, let's just put these on the table and see where there's agreement, see where there's disagreement, see where there can be compromise. And so it's not like, an ultimatum, either take it or leave it. It's just, here's the framework of from the claimant's perspective of what we think need to be addressed. Whether we just take one piece of it or several pieces of it or pick and choose between them, that's what this committee is about. It's to find some sort of medium ground, to find some area of commonality, and maybe it just deals with the neck, or maybe it just deals with allowing commissioners more discretion than what they have, but maybe not up to the amount that has been proposed. But that's what this committee's about, Colette. So don't think that from myself or even Bud's perspective that we're completely married to this and it's got to be all this or nothing. These are the things that we felt were important to talk about. And I'd be remiss to not include something.
Yeah, no, I got that. And
okay, good. But what concerns me, what bothers me, and it's bothered me for 30 years, because I've been dealing with legislative matters on 308A for a long time. And originally on behalf of the Connecticut trial lawyers, I started this, and what really bothers me is this attitude that judges, or formerly known as commissioners, can't be trusted with additional discretion. And I'm perplexed by that, because you may find someone who's maybe in one case that you may not agree with, but I think overall they have a sense of fairness about overall. And believe me, they don't always agree with what I say or think or do, but I think overall they have a sense of fairness, and what we're talking about is having that ability in the right case. And if a judge doesn't agree that they should exercise it, then they won't. If they think they should exercise it, but not to the extent that maybe the claimant's counsel wants to, then they will. And maybe they'll exercise it more so than what the responding counsel or even the claimant's attorney wants to them to exercise it. But it always troubles me that we're pointing these people who are in charge of this multi-million-dollar system, and yet we cut off their ability to formulate and fashion the right remedy in the right case. And I think, one of the overriding, at least I see as the concerns of this committee should be, or consider, is it time now to give them some more leeway, a little bit more ability to fashion the right remedy in the right case? And I think it is. I really do. So.
Thanks, Nate. Anyone else with any comments, questions, concerns, and alternative ideas? I've been doing this for 25 years, and I'll tell you, oftentimes the neck injury or the neck surgery is as involved as anything with the back. And to me, it's always been a discrepancy that it is such a low number compared to the back, when it really has oftentimes the same debilitating impact on the injured worker as a back injury would. So, I don't know if 374 is the answer. I don't think 117 should be the answer. I think it should be some number higher than that. But again, that's just based on my experience from doing this for a long time, that it just oftentimes what's going on with the neck is just as serious as what's going on with the back. Anyone else care to chime in one way or the other? Go ahead, Rep. Conley.
Thanks, Rep. Quinn. I would say that I echo your recent comments. I think we have a few groups of people, and I think we did a good job talking today and prior about folks who have the debilitating injuries that can't return to work. And I think it's important that we keep in mind that the one proposal that was made to this working group and the 308A doesn't affect every injured worker. It only affects the injured worker who cannot return to gainful employment. And that's a very small group of folks. So the folks who have a permanency to their neck or other body part and are back to full duty don't get 308A. I don't want folks to think that they do. It's for the folks who can't return back to work due to their injury that happened while they were at work, and they're accepted approved work injury. So it's a very small set of people. I appreciate that we've talked in this working group about other sections of the statute that may not be utilized, such as the section of the statute that requires employers to find light duty work for folks who are able. Because I think if that section was utilized more and folks were able to return to work quicker, that folks who have disabilities, that have work restrictions, could find that new job or that new role in their current employer easier. I appreciate our conversations so far on voc rehab, and I think we could do more in this group and as a legislature in having more folks realize voc rehab exists, and maybe we could fund voc rehab in a better way. I understand there were stipends. We talked about stipends before, and how we can get folks able to get into voc rehab who do need that retraining, whose injuries limit their prior occupation. Because without new training and without new skills, folks are really left with very limited options. Social Security disability is one, social services is another, and getting folks who need a new job, a new training is something that we could possibly do better. And maybe we could address out of this working group, or maybe we can address out of subsequent legislation. Again, the General Assembly would have to fund that program in a different way so we don't have an unintended consequence of having more resources or stipends being mandated without a payment process. So I do think that's great. I do note the commission is changing the form to allow the applications to Voc Rehab to be emailed, giving more accessibility to folks into that wonderful program. And if we can all do our part to share that with folks about the program for retraining, it's very important. I do hope that if folks have other ideas, that they do present them. They might not know of ideas right now, but to present them before our next meeting. So I know we've talked a lot about an idea by 2 members of this working group, but if other folks, I don't want you to stay silent. If you have ideas, please present them to the working group.
Thank you, Rep. Conley. Marie.
Yes, I just want to talk a little bit about DWR, which is a fabulous program, and I do agree with everyone that I wish people used it more. Now, I just got into this field. It was 1992 when I first got my job in this field. So my knowledge of what things were like before the 1993 changes are limited to a historical perspective, and certainly I wasn't with the agency at that time. So I don't know about that stipend and how it was funded. I can tell you that the agency does pay DWR and funds them in some manner now. So if this group decides that they want to go down the road of maybe bringing back that stipend, I suggest that you really look at how it was funded then and how it is going to be funded now, because it may mean if we have to increase the amount of money that we give to DWR, then obviously we have to increase the assessment that we place on employers. So I just want to make sure that everybody knows that we do pay DWR for their services.
Marie, have you guys done any statistics as to how many injured workers do take advantage of Voc Rehab?
I don't believe that that's something that would be in our system, because it's got to be, and maybe Nate or Colette knows, it's got to be at least 10 years ago when DWR was actually taken out from under the workers' comp umbrella and put under, I think it's DSS umbrella now. So no, I wouldn't know how many people take advantage of that program.
Okay.
I would think they have statistics.
Okay. Yeah, I mean, again, just thinking of my own practice, maybe 10 to 20% of my clients ever apply for Voc Rehab. And oftentimes it's because whatever the result of the injury was, they've been able to return to their normal job and normal employment, or are earning equivalent wages doing something else. Nate or Chris, in your experience with claimants, what are your thoughts on?
I think it's less than, in my experience, it's less than that. I give every injured worker, I discuss with them about vocational rehab, and I make certain that they have an application, and they, whether they choose to fill it out or not, that's their choice. After the case is settled out, every judge tells them that they have a right to vocational rehab. It remains open. It's a good program. I will say this, the last 3 people that have applied were told something different than when the director spoke to us. And I remember specifically asking her, do you have to be at maximum medical improvement to apply? She said, no. I said, okay. I said, well, can you be on temporary partial and apply and start taking advantage of the program? She said, yes. And these 3 clients, well, one's not a client, one's a friend, but the other 2 clients were told the opposite, that they have to have permanent restrictions and have a rating to apply, which is different than what I think when you thankfully brought her on board, because I thought it was an enlightening discussion that we had with her. It was a little different. So what we're hearing what we understand and what's being communicated to our clients are different. And so I agree with Chris that it would be nice to find a way to get people more involved in this. And I've encouraged clients, even if you're on total disability, apply for it, meet with them and talk about it, because now's the time to start thinking, get in the mindset about what could I do? What would I like to do? You don't know necessarily what your restrictions are going to be, but you may have sort of a general idea, and that these people should, they'd be willing to help and talk to you about it. And it doesn't seem like they're as engaged as they could be, or from the claimant's perspective, they're not feeling like, well, I'm ready to work. But if the Division of Workers Rehab Services isn't encouraging that either, then it's just going to wait to the end of the game, if you will, when they get their ratings. And then by the time they apply and they go in 6 weeks, they're already eating up their specific. And so, then they're left with no alternative but to settle the claims and or maybe they've moved on to other jobs. So I just think there was somewhat of a disconnect. So between what's communicated to us and what's being presented to the our actual clients, who the system is there for. So, but to Marie's point, I remember this discussion about how Division of Workers Rehab really had and correct me if I'm wrong on this, representatives, but originally they had a separate budget. It was my understanding they had a separate budget, and then it was taken away out of the system, and it was mixed with, I thought it was Department of Labor or something. And I remember the vocational counselors were very upset by that, because they felt that their ability to do what they had to do was going to be diluted. And I don't know if that's true or not, but it's certainly underutilized, and it's unfortunate. So.
Thank
I
you.
would agree with Nathan. I would say probably 10% of my clients that I see participate in Voc Rehab, possibly even less. I would note that the full pamphlet on the injured workers' right to work for Voc Rehab, which is available at the commission, and that's what I tend to give out to people more than the form that's online, because it answers the frequently asked questions in the front. It's really a good resource. And it talks about, when to apply and to apply. You do have to, though, take it apart and put a stamp on it on the form. So if we could update that and get more folks in. I would say folks I know who have talked to Voc Rehab assessments, they do need permanent restrictions, which I think is when it gets us at that program where a lot of times when someone gets permanent restrictions, they get their rating and then they're entitled to benefits for a certain period of time. And for some folks, those weeks could be, not very much. For some folks, those weeks could be longer. And I think the amount of weeks that folks get benefits, unfortunately, is limiting their choices on what programs they can attend. Because if you're only getting benefits for 11 weeks and you have an opportunity, by the time you send in your application, meet with a person, and I understand it's a lot via Teams now, learn about your options, your 11 weeks of payments may have ended. And then you're deciding as the injured person, can I participate in this program that is so many weeks long when I have only a few weeks of income left? And I think that folks aren't taking advantage of the program, not because the program isn't great. They're not taking advantage of the program because they can't afford rent, childcare, gas mileage back and forth. They can't afford to eat while they're on the program. And I think that's getting a lot of folks underemployed, getting jobs that they can get quickly, and then with a lot of those jobs that folks can get quickly these days, they may be part-time jobs or they may be shift work where folks can't have reliable shifts to then sign up for a Voc Rehab program because they're dealing with the basic needs of eating, living, and housing. And we're limiting folks on being able to get the higher salary jobs that you need a certificate for, need a training for. So I would say our problem is by the time folks get those permanent restrictions, their end of the workers' comp checks is the amount of weeks they're entitled to is usually ended, because usually the rating happens. If there's a way that we can get folks in earlier or provide additional benefits, be it a stipend, be it the 308A proposal by Nathan and Bud, something where we can bridge folks with some sort of an income while they get a certificate, while you get a program. We'll get folks from that low wage job into more of the job and the wages that they had prior to injury, which I think is the point of the voc rehab program as it stands. So I would say probably less than 10% of folks use it, and the main reason they don't use it is because they can't afford to eat while they're taking the class because they don't have any income.
Right. No, I agree. I agree. Okay, any other comments, questions, concerns? Okay. As Rep. Conley said, anyone has anything else that they want to provide to us, please do so. And if you want it disseminated to the entire group, we will gladly do that. If there aren't any other questions, comments, concerns, then our next meeting would be January 16th at noon, again on Zoom. And we'll continue the discussion at that point. And if there's nothing else, if I could have a motion to adjourn.
So moved.
Second,
Second.
all in favor?
Aye.
Aye. All right. Thank you very much.